And hello, everyone. Today we are going to be discussing student rights and restriction. This presentation has been done by Michaela Bruns, Patrick Harwell, and Elena Wassel. Let's continue. Today we'll be discussing the following parts of the students' rights and restrictions: dress and appearance, freedom of expression, search and seizures, cell phones, due process, classroom harassment, corporal punishment / discipline. We will start with Michaela. She will be discussing freedom of expression, dress and appearance.
In school, students do have First Amendment rights. However, schools can regulate these rights depending on if they are protected by the First Amendment. I'm going to explain the difference between protected expression and unprotected expression. Protected expression is expression that is protected by the First Amendment. There are two types of protected expression: pure speech, which is spoken or written words, and expressive conduct and symbolic speech, such as wearing a cross or peace sign on a shirt. Unprotected expression is expression that is not protected by the First Amendment. This could be vulgar or offensive speech that may lead to fighting, threats, or criminal activity.
Well said, Michaela. Now, going over freedom of expression. Students maintain their constitutional right to free speech and peaceful assembly. Schools may take action to maintain a safe and functioning learning environment. As Michaela was saying in her video, the difference between pure speech and expressive conduct. Protected expression under the First Amendment is pure speech, spoken or written expression, and there is expressive conduct, a symbolic speech, such as wearing a cross or a peace sign. Schools can regulate this expression for hygiene, safety, and to prevent materials and substantial disruptions to classroom operations. Tinker Voices Des Moines Independent Community School District, 1969. This is when students wore black armbands during the school day to protest the Vietnam War. The court in the end concluded that wearing the armband did not cause material and substantial disruption, and therefore the school could not discipline the students for wearing them. This case helped define material and substantial interference in the schools. And here we're going to Elena Wassel.
Hello everyone. Today we're going to be discussing students' rights and restrictions, and specifically in my section we are going to be talking about student search and seizures policies, cell phone policies, and due process. Very excited to share this information with you guys, and I hope you enjoy.
Well said, if I don't say so myself. And I did. Now we're going to go over search and seizures.
Hello everyone, your girl Elena's back, and now we're going to be talking about search and seizures. The U.S. Supreme Court ruled in 1985 the 4th and the 14th Amendments protecting persons of unreasonable searches and seizures apply to public school students as well. So, within this section, we will be discussing all the rights and what you cannot do, some examples of where people went above or crossed the line. And so we're going to be discussing all of that on what you can and cannot do with a search and seizure policy.
Okay, back to search and seizures. To conduct a lawful search of students, school officials must establish reasonable cause that a student has broken a school law or a normal law. Ensure the search is reasonable regarding the age and offense of the crime. A reasonable cause is a lesser standard than the probable cause standard for the issuing of warrants, and instead requires more than a hunch that a violation of school rules was done. Here we're going to be discussing the case New Jersey versus TLO, 1985. TLO was a 14-year-old student, and because she was underage, we were unable to get her name. But TLO, a 14-year-old student, was reported to the principal's office because of smoking cigarettes in the bathroom of her school, which is against school rules, thus allowing for a search. When TLO denied it, the principal searched her purse and found 2 cigarettes as well as a pack of rolling papers. Because the rolling papers were found, that caused for further searching, where she found marijuana, plastic bags, a significant amount of money in cash, and a list of names. Both searches were justified because of the reasonable clause to conduct them and because they were not exclusively intrusive. There's many different types of school searches. Some of them are school and school ground searches, student vehicle on school premises, out of school extracurricular activities, a student's vehicles located near but off school property while the student is still in school attendance, or while a student is in transit to or from school. Now, as I was saying, there's a lot of different types of searches that go on in schools, and one of them that's the most intrusive of all is the strip search. It's not very commonly done, but it is allowed under the reasonable clause from the New Jersey versus TLO. In the Educator's Guide to Texas School Law, it said, many commentators advise that school officials should leave strip searches to parents or the police, except in circumstances of imminent harm. The use of magnet meters, metal detectors, and breathalyzers. Now, magnet meters are usually like the big metal detectors that you walk through, and they're talking about metal detectors being the small waving bands that they go across you. Under these all fall under administrative search, which is when all students are searched as a daily routine. This ensures the safety of students and no harmful weapons such as guns or knives can get through. Now, some people questioned if the breathalyzer actually came under this, but it is very similar to the use of metal detectors. There was a story in the Educator's Guide to Texas School Law where they were discussing students going on a bus trip at 5 a.m. and one of them passed out and the other one became ill. They assumed this was because of alcohol, and they had everyone on the bus take a breathalyzer test. One of the students argued that this was against the rules, but indeed it was not. It was like, amplified, justified, and balances student personal privacy rights with the interest of the school and ensuring a safe school environment. And then they were trying to ensure a safe school environment by doing the breathalyzer test, and it was perfectly justified. Locker and desk searches. What I found very interesting about this, and that it makes perfect sense, the lockers and the desk of the school are property of the school, and the school may limit student exceptions of privacy whenever they want. If there is reasonable cause to search the lockers or the desk of the student, then it is allowed by the school. There are other forms of search, such as search of cell phones and electronic communications, the use of sniffer dogs to conduct searches, and student drug testing. All of these searches fall under the reasonable clause of the New Jersey versus TLO law. Just a little bit of a recap. Reasonable cause will support all of these searches. Schools should set visible and specific rules, as well as searches and seizure policies for all to see. I believe the rules should be sent to all parents as well as students. This policy should be written with the assistance of an attorney and make sure when it's approved, it should be shared with all employees to make sure there's no question on what to do for search and seizures. Now we are going to discuss cell phones.
Hello! Now we will be discussing the use of cell phones on school premises. So, most of these are determined by the district. So I can only find a couple of rules that are very broadly covered by everyone, and I hope you all enjoy them, and I hope it makes more sense. Bye!
And there are 7 common rules for cell phones that are in school districts all across the United States. Cell phones use is prohibited during school hours. Cell phone check-ins are required, and all that means is that they have to turn their phones into the front office, maybe a homeroom, whatever teacher, and they get them back at the end of the day. Some schools I was reading about are very forward-thinking in technology and actively use cell phones in classrooms every day as an educational tool. So sometimes that will be the case. Cell phones are okay to use during breaks, typically like lunch breaks, in between classes. And it's like some schools do not allow it during restroom breaks, so you'll just have to see what happens with your district. Cell phones in closed containers. I thought this was kind of odd. It is okay for students to bring cell phones to school, but they have to keep them off and in a closed container such as lockers, cars, and backpacks. I was like, that might be a common rule. It makes sense, but I feel like you should just leave them alone. Cell phone liability limits. The school absolve themselves of any liability for the theft, loss, or damage of cell phones brought on school grounds. This limitation of liability also extends to the unauthorized calls, text, or photos on school grounds that could entail criminal activity. This is just to save the school's butts in case anything bad happens with the cell phone. Cell phone disciplinary action. This also refers to, by the district, it all comes to what they do and what they want. This could include confiscation of cell phones for the day or even to a year. Could also result in detention, suspension, and a parent-teacher conference. Now we will be discussing due process, which Patrick Harwell will discuss later on in his slides as well.
Hello again, and we've made it to the end of my discussion. We are going to be talking about due process last. Due process is a legal requirement that the states must respect all legal rights that are owed to a person. That includes life, liberty, and the pursuit of happiness, and property. So, we're going to be discussing that and its rights and how it pertains to students. Okay, bye!
Due process. Due process claims hinges on the answer to 3 questions. Did the state take action? Did the state deprive the individual of life, liberty, or property? Or did the state provide the process that is due for such deprivation? Due process decisions balance the right of individuals against state police powers. Police powers are the powers each state may act to protect the public's general welfare. Due process and school suspension or expulsion. The state cannot deprive you of your basic rights without allowing you the proper legal proceedings such as a trial. Every student has the right to their education, and when that right is taken away, the student is entitled to due process. Rights students would have in a due process hearing. Know what specific rules were violated. Have the decision regarding the suspension, expulsion decided by an impartial 3-person panel. bring the evidence and witnesses on students' behalf, bring in legal counsel, have the hearing be closed to the public to protect the privacy of the students. Due process is just supposed to be helping anyone with legal rights, and they have the right to know why they were not given an education. And here we're coming to Patrick Harwell. We will be discussing classroom harassment, discipline, and corporal punishment.
Hi, my name is Patrick Harwell, and in my section of our presentation, I'm going to be covering classroom harassment, student discipline, and corporal punishment. Most of my topic is covered in the Texas Education Code, Chapter 37, dealing with student discipline. So we'll talk about bullying and harassment, discipline, including the need for a code of conduct, certain teacher rights, suspension and expulsion, and disciplinary alternative education programs, as well as the use of corporal punishment, which varies widely district to district, but is allowed at the state level. So here you go.
Oh boy, I'm excited to learn about that. Now let's go on. Classroom harassment. Harassment. Persuasive and persistent contact that interferes with the targeted student's ability to benefit from class due to a hostile environment directly affects the student's academic performance or otherwise adversely affects the student's educational opportunities. Bullying. An act or series of acts between any students and another student that harms them physically or emotionally, infringing upon their rights. Chapter 37 of the Texas Education Code deals with student discipline, code of conduct, teachers-initiated removal, suspension, DAEP, and expulsion. Tech Chapter 37 requires that each school has a code of conduct. This set of standards for student behaviors and outlines types of behaviors that will get students in trouble. Students can only be punished for behavior after they have been advised against that behavior. A code of conduct describes what disciplinary actions will be taken for a given behavior. Most codes of conduct leave room for teachers and administrators to use discretion to consider intent. Teacher-initiated removal. Chapter 27 was written with the intent to give teachers more authority. The goal for teachers is to maintain effective discipline in the classroom. There are 3 types of teacher-initiated removal. Removal for assistance, sending kids to the office. Discretionary teacher removal requires parent/teacher/administrator/student conference. Mandatory teacher removal, only required when a student commits an offense worthy of removal to a DAEP or expulsion. For the discipline, we'll be covering suspension and expulsion. For suspension, criteria dependent on and defined in the school's code of conduct. This limits suspension to 3 days per suspendable offense. However, multiple offenses can stack up and add more days. This and rules for in-school suspension should be defined in codes of conduct. Expulsion defines behavior that requires expulsion: possession of weapons, assault, arson, murder, indecency with a child, murder, felony, drug offenses, and more. Schools are very limited on what they can expel a student for, as expulsion is the heaviest consequence a school can level. DAEPs are used almost in place of expulsions. Alternative education programs. Disciplinary Alternative Education Program, otherwise known as DAEPs. Chapter 37-006 lists offenses for which a student must be removed to a DAEP. These criteria are for offenses on school property: any felony, assault resulting in injury, certain drug offenses, certain alcohol offenses, inhalant offenses, public lewdness, and indecent exposure. These criteria are for offenses at any location: false alarm or report against a school, terroristic threat, Title IX 5 felony, aggressive robbery, aggravated robbery, the retaliation against school employees. Schools also have the right to use discretion when considering a DAEP placement based on behaviors outside of this criteria. A heavier emphasis has been placed on students' retention in public schools, so DAEPs have become the replacement for expulsion in many cases. They are designed not to be holding cells for soon-to-be dropouts, but rather structured environment where students will have the most success learning. Corporal punishment. Chapter 37-001 of the TEC allows corporal punishment in Texas schools. It's a very debated topic. Parents are allowed to refuse and must submit a letter stating so every year. Many districts form different policies according to their individual codes of conduct, banning corporal punishment altogether, limiting on explicit parental consents, limiting the school officials who can inflict corporal punishment. And here we have reached the end of our presentation. Here are our resources. Thank you so much for allowing me to talk to you guys today. It was fun to talk about students' rights and procedures. Overall, it is very important for all of us to make sure we have a great understanding before we become teachers on all of these rules so that we can provide the students with the best experience. And thank you guys. Goodbye.